In the interim, so is this something that was obtained via right-to-know request, John?
I don't know if I did, sorry. I don't know if I did a right-to-know request on that or if I just asked for that. Dr. Littlefield, do you remember?
Honestly, I don't, because we get requests, and I'm not, at this point in time, I'm not sure which was a right to know and which may not.
I think it might have been a right-to-know request, Phil.
Okay, so let me ask you this, Dr. Littlefield. Could you ask Matt how long it took him to put all this stuff together? I mean, I'm asking you.
Are you asking me?
Could you please ask Matt? Yeah, because obviously, I'm not supposed to communicate directly with.
Oh.
Yeah, there were 3 right-to-knows from Mr. Liskars, and I would say they generally, all 3 of them probably took me, when I got them, took me 3-4 hours, to get them, where I had to sift through them and make sure I had the information. So 3-4 hours it took me.
Okay, thanks, Matt. Thanks, Phil.
For each one, that is.
For each one, okay.
Madam Chair, Mr. Dembo, in the United States of America, citizens have a right to access information from the public bodies that they pay money for. And this process is new to Hooksett. How we informed the Hooksett 8th grade parents, we were not informed of it. So a right to know is simply a request for information that we citizens, and when I say we, I am a Hooksett resident, but I'm also a Hooksett School Board member, and basically you asking the principal how long, how many hours, because you've done this before, is a way of intimidating the citizens from asking for information that they rightfully have access to. So I take offense to that. There's nothing wrong with asking government officials, people that we pay salaries for, how much information we need. And I also remember at the time, I believe you asked this question, that I also recommended to Dr. Littlefield that this is something that with the right to know request could be done by the IT staff, because I think it might have been you that made the comment about we shouldn't be taking our principals away from teaching or something to that effect. Mm-hmm. So, nobody told this administration to have the principal take time to gather this information. But if your suggestion is that Hooksett residents should not ask for information about what's going on and being communicated because that information is not readily available, I wholeheartedly disagree with you, Mr. Dembo.
So, John, the reason why I take issue with it is because I just want you to try to guess how many right-to-know requests you've submitted since you've been on the board. I have no problem with folks, like, on occasion, when it's valid, submitting requests. You have submitted, I don't know, 30, 40, 50 maybe since I've been on the board via SAU email because you copy everybody. And that concerns me because, as Matt just alluded to, and actually Matt Woodrow at our SAU meeting last week, that as tech director, he spent 70–80% of his time working on right-to-know requests. That's what concerns me. So this is tied to that.
Madam Chair, I would advise the board to review the 91A law. As a government body, we are not supposed to ask why people want this information. We are not supposed to infer that we're burdened by it or anything else. We're supposed to only ask them if there's any questions that are unclear in the request. We're supposed to ask. If there's any cost involved, we're supposed to tell them about that. But we are not, as a board, supposed to pry into the reasoning behind these. And I can't quote it right now, but if you review the law, you will see it does speak to that. So I think we should avoid that.
David, I'm not saying we avoid that. I'm saying we should avoid incessant requests. That
the word incessant, Phil, you have just characterized a citizen's right to know request. That is what you are not supposed to do. You're not supposed to pass judgment on whose right to knows are valid and not valid. We're just supposed to provide the information through the right to know law to the citizen. That's all we're supposed to do as a body.
David, and again, my concern is, are folks utilizing their time that could be better spent, is what I'm saying.
Yes, Mr. Liskar.
Mr. Dembo continues to harp on this one, so I suppose it's worth talking about. Mr. Dembo, there was a death in my family. I missed the non-meeting with the attorney. I asked you, I asked the clerk, I asked the administration, I asked Chair Corcus. I couldn't ask Mr. Pearl because he left the meeting. And nobody would provide me that information. I now understand why, because it seems like what was discussed at that meeting was the ambush that occurred at the next meeting. So I understand maybe why you were hesitant about not sharing that information, but you have no right to do that. I am an elected official. That information should not have been kept from me. There is nothing that supports a secretive government. Whether you want one or not, it is not supported. So you can put pressure on me not to file right-to-know requests. You can put pressure on the Hooksett citizens not to file it. But you know what? It's their right, and it's my right, Mr. Dembo. That's the government I live in.
Just because that was not a secretive meeting. That was a non-meeting that we are duly had the right to conduct with our lawyer. And my understanding is if you are not present in a non-meeting, you are not to discuss with anybody else what goes on in that non-meeting. So it is unfortunate that you were not there, but I don't believe that we have the right to discuss it even if you are a board member. And if I'm wrong, but that was my understanding of that situation. So there was no secretive meeting. That meeting was held rightfully so with our lawyer. We had every right to do it, and we were bound not to discuss what was discussed in that meeting. It was not secret.
Yes, Mr. Liskar, then Mr. Pearl.
You know, it's interesting. It's taken me this long to get that out of you, clerk, because you've never shared your opinion on that before, which is surprising, because I think it's wrong that you don't want to share information in a meeting. And this is not a non-public meeting, just to be clear. A non-public meeting, we're all sworn to confidentially. That was not a non-public meeting. That was a non-meeting, which is, that's when you talk to your attorney about strategy, maybe with negotiations, or strategy with an ambush. How are you going to do it? But you can share that if you want. But you all chose not to. That's wrong. That should be a big red flag for people in this community when a board operates in secret.
It was not secret.
Yes, Mr. Pearl.
I would just like to add that it being a non-meeting, no one is bound to secrecy, but the attorney, Dr. Littlefield probably as some parts of his employment, we are bound under attorney-client privilege, but we control that attorney-client privilege as board members. So, and we've been told this by more than one attorney, you could leave that non-meeting and talk about it. It's not generally to the advantage of the board to share it with other non-board members. But it's not a good defense to say that you are bound to not talk about it with anybody, particularly another board member. That really is just not true.
Yes, Mr. Dembo.
So, David, again, I think you're more well-versed in non-meetings, and it's not considered a meeting, whatever. I don't even know the terminology, but I'll tell you two things. There were no notes taken at the meeting, which to me indicated that stuff in that meeting is confidential. That's why I didn't want to even speak about it or write notes about it. Point number two, all the information that was contained in that meeting was brought out last week, and that stuff pertained to every board member. It wasn't just one person, a part of an ambush. All those things that we approved applied to every member on this board.
Are there any questions or concerns regarding the parental notification about high school selection events that Mr. Liskars would like to add to the public record?
No.
Okay. Moving on the agenda.